Welcome to Gitterman, and Feld. This video presentation is for preparation in having your deposition taken. A deposition is an informal proceeding in which another party is able to ask you questions while you're testifying under oath. The testimony has the same force and effect as if you were testifying in a court of law, so don't be misled by the informal surroundings. Also, you're the only person who's testifying under oath. The defense attorney is not testifying and can make things up when they're asking you questions. If you agree and accept the defense attorney's representations, it now becomes your testimony, and it's your testimony under oath, under penalty of perjury. The important thing in a deposition is to be accurate in your testimony. We already know you're going to be honest and truthful, but accuracy is something that's a little bit different. It means that you need to be certain of your answer. You're allowed to make estimates. You're allowed to provide approximations. But when you do so, you should make sure that everyone understands that's what you're doing, such as, I'm guessing that's when it happened. I think it happened around this time. That's what I seem to remember. Try to talk about what you know, not what you don't know and not what someone else has told you. If you are going to relate information that someone else has told you, make sure you let the questioner know that you're relaying information that was told to you. It's not something that you know, but something that was told to you. There is no rush in a deposition transcript. Nobody holds a gun to your head and says you have to answer the question right now. You can take your time, think about the question, and then provide the answer to the question with the knowledge that you have best. In the event that you're not able to recall something, that's a perfectly acceptable response. For example, if I were to ask you what you were doing 5 years ago at 3 o'clock in the afternoon, the answer to that question should probably be, I don't remember. As opposed to, if I were to ask you how many children I have, the answer to that question should be, I don't know. The difference between I don't know and I don't remember is when something has happened in your life and you just simply can't pull it out of your memory banks, that's an I don't remember. On the other hand, if you don't have any information in which you could answer the question, then it's I don't know. For example, you don't know if I have children. You don't know what their ages are. If I do have children, are they male? Are they female? You just don't have any information. So that's an I don't know. When you're answering questions in a deposition, there are only two answers that will fully and completely answer a question and be accurate. Those answers are yes and no. If you can answer a question with a yes or a no, that's your obligation, to fully and completely answer the question. Anything else, you're no longer answering the question. You're usually providing additional information, or you're not actually answering the question which is asked. It's easy to answer questions in a deposition. There's no question on the face of this planet that they'll ask you that you will not be able to answer. At some point in time, because I don't know and I don't remember are also answers to questions. The hard part in a deposition is listening to the question. We tend to project and not pay close attention to what's being asked of us. And as a result of that, we tend to not be accurate in our answers because we're no longer answering the question which was asked, we're answering a question that's in our head. So when you're doing your deposition, take your time, listen to the question. If you don't understand the question, ask for clarification. You cannot be accurate in your answer if there's a word, a phrase, or a sentence that you don't understand. Because if you don't understand what's being asked of you, then you're just guessing at what the question meant. And that's just no way to be accurate. We want you to be as accurate as possible. You're not going to win your case in the deposition. You're not going to persuade the attorney of how seriously you're injured. Frankly, they have very little interest in your level of pain. Most of the questions they will ask you, they already know the answers to. They just want to make sure that you're going to give them the answers to the questions they already have the answers to. Generally speaking, the deposition will cover 5 or 6 broad subjects. They'll want to know who you are, when were you born, where did you live, who do you live with, are you married, do you have children, who you are. They'll want to know about your educational history. Where did you go to school? Did you graduate? Did you go on to postgraduate work? They will want to know if you have any licensing or vocational training. All of these questions kind of relate to who you are. Ultimately, they'll get to tell us what happened. How did you get hurt? Who did you report it to? When did you report it? Who did you go see for treatment? They'll want to know about your medical history. Since you got hurt, tell us what doctors you went to see. Tell us what treatment they provided. Tell us what treatment they recommended. And they'll want to know about your current medical condition. How are you doing now? How do you spend your days? What are your activities like? And these are all questions that are there to help them better understand your case. The 2 most important areas will be your work history, because these are areas where they may not have all the information. Who did you work for? When did you work for them? What were your duties? How long did you work for them? And the other area will be your past medical history. Have you ever had problems with the body part that you injured on the job? Who did you see for that treatment? What happened? What was the end result? Did you have any residual problems? Did you have any prior workers' compensation claims? All of the information that the attorney is seeking is in order to help them properly investigate and evaluate your case. At the same time, they'll be evaluating you as a witness. Are you direct? Are you forthright? Or are you evasive and argumentative? These kind of assessments all play into their report to the insurance company as to whether or not this is a case that they want to continue to litigate or perhaps move towards a resolution. So when you're testifying, make the best presentation you can. You should be dressed appropriately, as if you're going for a job interview or going to church. You want to be presentable and you want to show that you have an interest in your case. But having an interest in your case is different than trying to persuade the defense attorney about the merits of your case. If there's one thing I've learned after 34 years, no defense attorney is persuaded about the merits of a case based on the testimony of the individual who's seeking the benefits. Within the legal system, the defense attorney has an opportunity to speak with you one time. So they're going to use that one opportunity to ask you as many questions as they can think of, whether related to your case or related to you. Your job is simply to answer them. If there's an inappropriate question, then your attorney who's representing you at the deposition will object and instruct you not to answer. Anytime you hear your attorney telling the other side, I'm instructing my client not to answer that question, please do not answer that question. If you hear your attorney objecting to a question, please allow the attorney to object to the question and listen to the objection. The attorney may be communicating information to you about the nature of the question, such as that question's compound. It's asking for 2 different things in the same question. Which question do you want them to answer? Things of that nature. You may, from time to time within the deposition, hear your attorney say, you've answered that question. They're communicating to you, stop talking. Or they may say, that's not the question which was asked. Again, that's just a listening issue, and the attorney is trying to redirect you because their job in the deposition is to protect your rights. So they want to make sure that there's a good, clean record and that the information that's being conveyed is heard by the other side. Good luck in your deposition, and you will be meeting with an attorney before the deposition in further preparation for it. Thank you for your attention.